Chapter 12, Transfer of Title. Chapter 12 is going to tell us how we can take this thing we've been learning about, this title, which we go back to Chapter 7 when we talked about, fee simple estates and our title to property, this bundle of rights that we have this title to. How can we transfer it from one person to another? And that's what this whole chapter is about. And they start off with a couple of terms that we want to know: a deed and bill of sale. A deed is, a way of transferring real estate, must be in writing. A bill of sale is also in writing. It conveys personal property. So at a real estate closing, you're going to see both those documents: the deed to convey title to the real property, and a bill of sale to convey ownership of any personal property items. A grantor is is the name we give to the person that's selling real property, granting real estate, and the grantee is the person who receives the deed. If you will, the grantor is the seller, the grantee is the buyer. Under the bill of sale, we call the seller a vendor, and under the bill of sale, we call the seller a vendee. So, 4 ways to convey title: voluntary alienation, involuntary alienation, by will, and by descent. Voluntary alienation, found on pages 219 to 227, is what happens in most real estate sale transactions. Somebody voluntarily conveys their title from one party to another. An involuntary alienation is where the grantor loses title, frankly, without their consent. They're forced to convey title. And we'll learn a little bit about when you can do this involuntarily. You can transfer title by will, and we can transfer title by a law called the statute of descent. So by will is when we transfer title when we make a will. By descent is when we transfer title because we don't have a will or our will is invalid. Those are the 4 main ways of conveying title to property. So, starting with voluntary alienation, we're using a deed here to voluntarily convey from the grantor to the grantee. We have to have a grantor who is has the legal capacity to convey. We have to have a grantee that we name on the deed. We have to have consideration. So, the seller of the property has to be getting something for their sale, usually something in terms of monetary's worth. So usually the seller's, getting money for his conveyance. Granting clause. In our deed, we have to have words of conveyance, so we can legally grant from one party to the other. So those magic words have to be in the deed. We have to have a legal description of the property being conveyed, and we have to have exceptions or reservations stated in the deed. So maybe we're conveying the title of this property, but perhaps we're only conveying just the air rights to the property. So we would have to have exceptions in there to show that we're not conveying the surface or subsurface rights. Or perhaps in the deed we're only conveying the subsurface rights, the oil, if you will, or the gas deposits to somebody. Reservations might be we're conveying this title and we're make it contingent that the new owner use the property in a certain manner. And if they don't use the property in a certain manner, they'll lose title, it'll come back to us. So those should be stated in the deed. The seller will sign the deed. The buyers don't have to sign deeds, but sellers have to sign the deed showing that this is a conveyance they're making with their own free will. Most deeds are notarized by a notary who acknowledges that this is a free and voluntary act of the seller and that the buyers are the people that they claim that they are. They're not fictitious people, that they can be named and identified. All parties can be named and identified, and it's a free and voluntary act. So we should have the deeds notarized, but they don't have to be a valid conveyance in Illinois, but they should be. Then we deliver the deed, and it's accepted, and at that point of acceptance, of delivery and acceptance is when the deed has passed title to property. Deeds are only useful during the lifetime of the grantor. When the grantor dies, even if they've already made a deed, that deed would have no consequence. It would not be a valid instrument to convey anything. So deeds are only useful while the grantor lives. Covenants in deeds. Seller is making these promises to the buyer with a general warranty deed. If we use a general warranty deed to convey property from a seller to a buyer, the grantor or seller is promising they have the covenant of season, the promise or the right to convey. I promise against encumbrances. I'm going to tell you all of the encumbrances on the property. I'm going to promise you quiet enjoyment, which means nobody of greater title is going to step forward and say that they're actually the owner of the property. I'm going to have the promise of further assurance, Mr. Buyer. If you ever need any other document, you can come to me and I will give you any document now or forever. And Mr. Buyer, I am making these promises forever. So for as long as you hold title, you can come back to me and I will make good on my promises. I'm making these promises even from the very beginning of title. So you have assurances that as long as you own title, I will be there to stand by it and warrant this title. So these are all good covenants found in the warranty deed. A special warranty deed, if we convey title voluntarily by using a special warranty deed, there are covenants. But the covenants is that the warranty, that the grantor is in title. And then the other covenant or promise is that it's unencumbered. It's an unencumbered title. Those are the only two promises made with a special warranty deed. In a bargain and sale deed, we grant that I promise you, Mr. Buyer, that I have fee simple ownership. It's relatively free of encumbrances, and I promise you quiet enjoyment. So there are some promises with the bargain and sale deed. Not all the promises made with a warranty deed. And with a quitclaim deed, there are no promises. No promises, no covenants, no warranties, no protection. So the deed with the greatest protection for the buyer is the warranty deed. The deed with the least protection for the buyer is a quitclaim deed. Usually, quitclaim deeds are used in court cases, and the court uses them to quiet title. An example might be at the end of a divorce proceeding, say Mr. Owner has to convey whatever interest he has in the property to his spouse, and that's part of the divorce settlement. So he would use a quitclaim deed to convey whatever title he had to the wife, in which case she now owns the property by herself. Let's say they owned it in Tennessee by the entirety, and he conveyed his interest to her. Now she owns it by herself. With land trusts, the deeds, as you saw before in an earlier chapter, we would use a deed in trust to convey to the trustee. It's really a form of a special warranty deed is really what it is. If the trustee had to convey to somebody, they would use a trustee's deed. Deeds used pursuant to a court order, we could call them sheriff's deeds, mortgage foreclosure deed, a tax deed, tax foreclosure, administrator's deed, an executor's deed used in a will. All of these deeds are forms of quitclaim deeds. a master's deed of reformation is a deed to correct an incorrect deed that's been recorded. Again, all of these are quitclaim deeds. So the only deeds that we have in Illinois are the warranty deed, the special warranty deed, and for our purposes, the quitclaim deed. But for our purposes, we won't talk about the deed of bargain and sale. Let's just say we have 3 deeds in Illinois. So we need to know there are 5 promises that the grantor is making from the beginning of title to forever and under the general warranty deed. The special warranty deed just has 2 promises, and the quitclaim deed has no promises. Page 225 refers to the Illinois Transfer Tax Stamp Act. In Illinois, certain deeds, before they can be recorded, have to carry with them transfer tax stamps. And basically what transfer tax stamps look like are postage stamps. They're little men, old men, and you stamp them on there, eagles and whatever. They're not any big official looking document, but it's a way for the state and the county to raise money by putting a tax on the deeds that we use at closing. There are some deeds that are exempted from transfer tax stamps, and you probably should be familiar with those, and you'll find those on page 225, those that you don't have to have transfer tax stamps with them, way at the bottom. I'm sorry, 226, way at the bottom of 226. But transfer tax stamps, these stamps must be attached to these deeds. And the transfer tax stamps go to the state and to the county where the property is located, and again, they have to be attached before they're going to be able to be recorded. So the seller's got to buy these. So the question is, how much does the seller pay? Well, the state portion of this is 50 cents per 500, and the county portion is 25 cents per 500. For the whole tax is 75 cents per 500. So here are some transfer tax stamps rules. If the sale price is less than $100, no tax. The taxable value can be reduced by the amount of the assumed mortgage. I'll show you what that is and what that means in a second. Tax must be paid prior to recording of the deed. And so here's the way we might compute this. Sale price of our property is $425,000. There's an assumed mortgage, and most of the exam questions, math questions you get on transfer tax stamps will carry an assumed mortgage. In real life, this doesn't happen hardly at all. An assumed mortgage is where the seller has a balance on his mortgage, in this case of $300,000, and the buyer assumes it. So the Transfer Tax Stamp Act says if a buyer is assuming seller's mortgage, he's technically not getting the full amount, so we will subtract that from the sale price, thus reducing the amount he's going to have to pay in transfer tax stamps. So if you see an assumed mortgage in your math problem, you can subtract that from the sale price. So in this case, the seller only has to pay on $125,000 after we subtract. And we have this business round if necessary. If after you subtract your assumed mortgage, you have an even number like $125,000, you can keep it. If it were an increment of 1,000, like let's say we subtracted and we had $125,200, we would round to $125,500. So we round up to the nearest 500. If we subtracted and had $125,600, we'd round up to $126,000. So if after you subtract you have a portion of 500, you need to round up, then divide by 500. Well, in this case, we don't have to round it because it's already rounded. And we would get 250. Divide 125,000 by 500, we get 250. We multiply that by 75 cents, and we get $187.50. That's the full amount of tax that our seller will have to purchase transfer tax stamps at. Remember, the full amount is 75 cents per 500. The state portion is 50 cents per 500, and the county portion is 25 cents. Of that state portion, half of that 50 cents goes to Illinois Affordable Housing Fund. So that would actually, whatever would go to the state, half of what goes to the state goes to the Illinois Affordable Housing Fund. And again, assumed mortgage, that's the only thing you can subtract from the sale price. In real life, sellers are paying on the full amount of their sale price because very rarely are buyers allowed to assume seller's mortgage. But on your state exam, they will show assumed mortgage, and that's that number you can subtract from the sale price. If your math problem has any other, like a purchase money mortgage or cash or whatever, that can't be subtracted from the sale price. So on your problem, you're going to look for sale price, you're going to look for assumed mortgage, you're going to subtract it, round up if necessary, divide by 500, multiply by 75 cents if you're looking for the full amount. If you're only looking for the state amount, 50 cents. If you're only looking for the county amount, multiply by 25 cents. We've been talking about transferring title by voluntary alienation. You remember when we started this lecture a little bit ago, we said there were 4 main ways of conveying title. Voluntary alienation, involuntary alienation, by will, and then by a thing called the statute of descent. So we've been talking about voluntary alienation, using deeds and sellers selling voluntarily. Now we're going to talk a little bit about involuntary alienation. This is when you're selling the property, when the property is being conveyed despite your wishes. You're being made to sell, if you will. And the basic ways that property could be transferred involuntarily from you are condemnation. They condemn the property and take it and build a new basketball arena. You can object all you want. You're going to lose the property, and it's going to be transferred from you. Of course, foreclosure, mortgage foreclosure, or if you're property tax foreclosure sales, involuntary action. Escheat. Escheat is when you die without a will, and the property is conveyed to the county where the property is located. We'll talk a little bit more about that in a second. Accretion and erosion is when you get the property or lose the property because of the action of wind or waterway, or we talk about a avulsion, a hurricane, or a big, a flood. Those kinds of things could take title from you and give it to somebody else, obviously involuntarily. Adverse possession is when someone comes and claims your property and sort of legally steals it from you. All forms of involuntary alienation. So besides voluntary and involuntary ways of transferring title, a third major way of transferring title to real estate is by will. A will is an instrument made to convey real and personal property after an owner's death. So while deeds are used while owners are alive, deeds are of no consequence when someone's died. A will takes effect only after someone's death. So a will has no consequence while someone lives. Our terms, testator, that's the maker of the will. A devise is the gift of real estate or the gift of real property. If the devisee is the person that receives the gift of real property. A legacy or bequest is a gift of personal property, and the legatee or beneficiary is the person that receives the gift of real property. So if you look at a will and we look at those particular terms, we'll know what they're referring to. It then transfers all the monies that are left after all the bills are paid to the people you want to receive under the will. Wills must be in writing. They must be signed by the maker as their last will and testament. You have to be of legal age, which is 18 years of age, sound mind and memory. You have to declare this is your last will and testament. Must be witnessed by 2 people, preferably people not taking under the if someone dies without a will, then we go to the statute of descent, which is the 4th major way of conveying title, the statute of descent. We have in Illinois a statute called the Illinois Statute of Descent and Distribution, and it says if you die without a will, and you're not a co-owner, so so you don't have a will. There's no co-owners to take the property like joint tenants or tenants by the entireties. Where does your property go? The state sort of makes a will for you called the Illinois Statute of Descent and Distribution. It says that if you're married with no children, your surviving spouse gets everything. If you're married and only having survived children, the surviving children take it all. So that's where you're married and no spouse, just children. Of course, if you're married with a spouse and with children, wife gets 50%, the children split the other 50%. An unmarried person who would die, so this is someone that doesn't have children or doesn't have a spouse, it goes to their father, mother, brothers, and sisters equally. If one parent is predeceased, then the surviving parent gets their portion. So for a single person, if they were survived by a mother because the father had died earlier, the mother would get the father. We start the will process by probating the will. Probate court proves or confirms the validity of the will. It determines all the assets the deceased person had, what they were worth. It identifies the persons who, the legatees and the devisees who are supposed to get these assets. It identifies any creditors and makes sure they're all paid from whatever proceeds that the estate has. We do have this thing called a holographic will, which is a will written in someone's own handwriting. Not a good idea. A will really should be prepared by professional people like attorneys. You got to be a little careful that there is, when these things are done in people's handwriting, sometimes the courts look askance at them, particularly if you've got one part of the will is in ink, the other part of the will is in pencil, and there's cross outs and there's erasures and stuff like that. But if someone did one, that would be called a holographic will. A non-compunctive will is a will that is, quote, written at your deathbed. They typically are for small sums of money. So if there's a deathbed will, it usually is personal property up to maybe $500 portion. Take a look at the study guide exercises on Chapter 12. Good luck.